to talk about what we're going to go over today, we'll talk about the benefits of international asset protection. We're going to talk about domestic versus international asset protection. We'll talk about a couple different types of international entities. We'll focus today on the LLC and the trust because those are the most popular. We'll also talk about the captive insurance company, or CIC. We'll talk about a couple different jurisdictions from an international planning point of view. And we'll also talk about the advantages of a variety of different jurisdictions. If anybody likes what they hear today, we do give presentations all across the country. So if you're a member or organization of some sort of group or business that you think could benefit from a in-person presentation, also feel free to shoot us an email as well. I always like to start with the basics. So if you've been on some of our other webinars before, you'll know we always like to give a little bit of background information. So, what is asset protection? And, the definition that I give for asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors while simultaneously still enjoying the benefit of the asset. And I'm going to repeat it because I know it's a really long definition, but the definition that I give for asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors while simultaneously still enjoying those assets. So what we do as asset protection attorneys is we help our clients protect any asset they have from any financial threat. The majority of our clients might be business owners, doctors, professional athletes. Maybe it's someone who received money in an inheritance or a divorce. And the type of assets we help them protect might be as simple as checking, saving, stocks, bonds, CDs, money markets, brokerage accounts. Might be real estate. Might be cars, boats, planes. Might even be membership interest in an LLC or shares in a corporation. Could even be intellectual property like trademarks, phone numbers, domains. Anything that's valuable to our clients we want to protect. And of course we want to protect it in any reason. Whether it's a short sale or foreclosure deficiency, a lawsuit, a car accident, a creditor, a judgment, a divorce, whatever that reason may be, we want to make sure that our clients are protected. So a lot of people always say, well, do I have enough assets to protect? And the short answer is yes. The less you have, the more you need asset protection. Now, obviously, the guy who has $50 million in the bank doesn't need asset protection in the same stages as the guy who only has $500,000 in the bank, or vice versa. I always like to give the example. Take one of our professional athlete clients that signs a football deal in the NFL for $50 million. Well, if he gets sued for $5 million, he's not going to be happy, but he still has $45 million left. Contrast that with the everyday Joe who maybe has saved up a couple $100,000 for retirement over their career. Well, if they get sued for $1 million, they're going to be wiped out. So the less you have, the more you really need to address the protection. And a lot of people say, well, what if I already have an asset protection plan? If you already have an asset protection plan, I think that's great, but have it checked out. Laws change every single year. A lot of people think they have a great a great asset protection plan, but they really just have a great estate plan, and there's a big difference between the two. Estate planning deals with when you pass away, where do you want your assets to go? Asset protection deals with while you're alive, how do you protect them? So if you have a plan, great, but definitely have it checked out. So a lot of people say, well, why do I need asset protection? And there's this cute little cartoon in the upper right-hand corner, and it's two lawyers talking. One says, I say sue, and the other one says anyone in particular. And I always get a few smiles when I show this, but unfortunately it's not funny. Just like we're smart enough to get together on a monthly basis and learn from one another, the lawyers get together. But they're getting together on a much more frequent basis, maybe once a week. And they're saying, who are we going to sue next? Is it going to be the lawyers, the doctors, the business owners, the car manufacturers? Who's our next target? There's over 100 million lawsuits out every single year, and that number is only growing. In today's bad economy, people are making less and less if they're lucky enough to keep their jobs. Why not go to any corner where they can hire an attorney free on a contingency fee basis and sue somebody? Doesn't cost them a penny, maybe 20 minutes of their time, and if they win, a lot of times it's tax-free money. The stats are that there's a 1 in 4 chance you will be sued in the next 12 months. The average person and company is sued 5 times over their lifetime. So if you have an LLC, on average you're sued 5 times. On average your LLC is sued 5 times. If you have more than one company, well, you can surely just multiply it. Now, again, I'm not trying to scare you. These are just the averages. These are just the stats. I have clients that have never been sued, and I have clients that get sued on a monthly basis. Really just depends what type of industry you're in. Really just depends how many employees you have, et cetera, et cetera. There's a 50% chance of divorce, and a lawsuit can cost you tens of thousands of dollars even if you win the case. And I think this is important because, unfortunately, our legal system makes it so easy to sue somebody, but so difficult and expensive to protect yourself. So to sue someone, you hire a lawyer on a contingency fee basis for free, but to defend yourself costs tens, if not hundreds of thousands of dollars. So the trick is not making money, it's keeping it. And the challenge that I give to all of our clients is for every 60 minutes you spend making money, spend 60 seconds thinking about how to protect it. Well, a lot of people say, well, I have insurance. Isn't that enough? And I am a big fan of insurance. I think it's cheap. It helps you sleep at night, and you can't go wrong. But with that being said, understand that 70% of lawsuits are not covered by insurance. Anybody who drives down the highway, especially in Florida, they'll see the big buildings. Whose name is on it? The insurance companies. They don't get that way from paying all the claims. My father used to always say, the big print giveth, the small print taketh away. So everybody knows in an insurance policy there's about 65 pages of what's not covered and about a half a page of what's covered. Your coverage may be inadequate. You might have $100,000 or $200,000 coverage on your car, but what if you get in an accident and someone's in the hospital and there's $1 million in hospital bills? Who do you think has to come out of pocket the rest? Your insurance company might go bankrupt. Now, if I would have said that, 5-10 years ago, you guys would have hung up the phone and kicked me out of the room. Today, we have Fortune 500 companies and banks going out of business. So who's to say the insurance companies won't be next? Insurance doesn't cover other uninsured financial risks and divorce. So essentially, insurance alone is not the answer. You need your own asset protection plan to supplement your insurance. I call it the belt and suspenders approach. So 3 maxims of asset protection. Number 1, you got to protect yourself before you have a problem. You don't buy car insurance after the accident. You don't buy health insurance after you get sick. You don't buy life insurance after you die. You need to be proactive and make sure that you put an asset protection plan together before you get sued. Also, you want to start with a very basic plan and add firewalls as needed. You don't need to do everything at once. I can't tell you how many times someone's read one of my books, they come into my office, and they want to do all sorts of crazy planning. And there's nothing wrong with it if your assets warrant it, and if your education and you understand it. But start basic and add firewalls as needed. As your assets grow, your personal and business assets grow, your plan can grow. As your education grows, your plan can grow. Probably the most important thing is don't look for one magic bullet or one right plan, one size fits all. Asset protection is not cookie cutter. I see a lot of other people, they do the same thing for every client. Every client needs to have an individualized, customized, and tailored approach. Everybody has different assets, everybody has different threats, everyone has different potential creditors. You got to protect somebody, whether it's a person or a business, in a manner that's going to help them. So beware of any, cookie cutter approaches. A lot of mistakes to avoid. Today we'll just go over the 5 killer mistakes. Number 1, hiding your assets. Asset protection is not about hiding. It's not about secrecy. It's about protection. I tell all my clients you should be able to tell anybody what you have and where it is. They just shouldn't be able to get it. And I also tell my clients that understand at some point somebody will be asking you where your assets are. Because if you get sued and you lose the lawsuit, and they put you in a deposition or have you fill a financial affidavit out under oath, you got to tell them the truth. And if you're not, you're perjuring yourself. So sometimes the cover-up's worse than the crime. A good asset protection plan should not involve hiding or secrecy. Also, you don't want to go titling all your assets to straws. I can't tell you how many times someone's come in and said, hey, you know what, I'm being sued, Mr. Presser, but I gave everything to my brother-in-law. Or, hey, I'm getting sued, Mr. Presser, but I gave everything to my best friend. I look at them in their eyes and I say, what actually makes you think that your brother-in-law or best friend has less legal and financial troubles than you? I can't make up the stories. I've seen times where clients have given assets to their brother-in-law. The brother-in-law gets sued and they lose the client's assets. I've seen times before where the clients give the assets to the best friend gets divorced, and the wife takes their assets. So you don't want to go titling all your assets to straws. Titling assets to your spouse. We see this a lot with our doctor, physician, surgeon clients. Not a smart idea, because nobody's immune from a lawsuit. Nobody gets up in the morning and expects to be sued. If the husband's the breadwinner, the wife could get in a car accident taking the kids to soccer practice. Nobody's immune from a lawsuit. You never want to commit any fraudulent transfers. The definition of a fraudulent transfer is transferring assets out of your name for less than fair market value after you have a present or potential creditor, and as a result, the creditor doesn't get paid. So I'll repeat that because I know it's long. The definition of a fraudulent transfer is transferring assets out of your name for less than fair market value while you have a present or potential creditor, and as a result, the creditor doesn't get paid. So essentially, it's you get sued or you get threatened to get sued, and you transfer assets out of your name. It doesn't work. Not only can the creditors try and claw back the assets, but they can actually sue whoever you gave the assets to. So more than likely, if you've committed a fraudulent transfer, you've transferred the assets to a friend or a relative, and now what you're doing, unfortunately, is you're bringing a loved one in the suit because now they can become a party to the lawsuit. So you never want to do that. And of course, most importantly, you never want to break laws. And we'll talk about this in a little bit more in depth when we talk about the international planning. And, really you got to make sure that whether you're doing domestic planning or international planning, that you're filling out all the proper reporting requirements with the Treasury Department, the IRS, and things of that nature. And, understand today's just meant to be, a small snippet of asset protection and international asset protection. Certainly can't give you all the answers in one 30 or 40-minute webinar, but, if I can get your mind thinking, then, we've done the job correctly. So what are some of the benefits of international asset protection planning? Number one, the U.S. jurisdictions lack jurisdiction over international assets. So if you have a proper international asset protection plan set up and the assets have properly been moved over to that plan, well, you're now outside of the U.S. jurisdiction. So a U.S. judge would not have custody or jurisdiction over those assets. Also, a civil creditor cannot uphold U.S. judgments against foreign asset protection vehicles. There's a lot of different good jurisdictions, and all of the good asset protection jurisdictions do not enforce U.S. judgments. Foreign jurisdictions have very strong asset protection laws. These are countries that are built on asset protection. So literally written into their law is very, very strong asset protection law. Protect your assets and maintain control over the bank accounts and investments. We'll talk about control a little bit later. It's the key phrase, the more control you have, the less protection. The less control you have, the more protection. So you really got to figure out a client's comfort level and see, how do you balance the control versus the protection issue. And there's a lot of strong barriers for a creditor to bring a fraudulent transfer claim. And again, we'll talk about this in more depth, but just to give you a quick example, depending where you are in the U.S. and whether it's state or federal, normally there's about a 4-year look back on a fraudulent transfer. In some of the offshore asset protection jurisdictions, the statute of limitations for a fraudulent transfer might be 0 years. It might be 1 year. It might be 2 years. So very short and very strong fraudulent transfer statutes. So moving right along, what is the difference between domestic versus international? Well, domestic asset protection simply means, protecting your assets inside the United States and using United States-based entities. Those are things like LLCs, limited partnerships, trusts, corporations, et cetera, et cetera. International asset protection is used to protect mostly liquid assets and investments outside the United States. Now, we can use international asset protection, to help protect real estate and companies and things of that nature, but you always get the best protection when it's liquid assets. And that's because you simply can't pick up a house and fly it to Nevis or fly it to the Cook Islands or fly it to Belize. You can transfer your money there. So while it does help protect other assets, international asset protection really gives you, that best bang for the buck and that most comfort level and best protection, when you're protecting liquid assets and or investments. So some of the two most popular entities that we're going to touch on today, and we set these up all the time, are the International LLC and the International Trust. And there's a lot of different variations of the International LLC, and there's a lot of different variations of the International Trust. So when you see LLC and you see Trust, understand that there's probably a dozen different ways you can create these. But an International Trust is really a trust that is set up in a jurisdiction outside the United States, and the assets are then hopefully conveyed out of your name and into this international trust. Now, when we set these up, it might be in one jurisdiction. You might set it up just in Nevis, or just in the Cook Islands, or just in Belize, or just in Switzerland. Again, there's so many different jurisdictions. Sometimes we'll set up what's called a hybrid trust, where we set it up in a couple different jurisdictions at the same time. No difference with the LLC. And we're going to talk a little bit more in depth and detail about the LLC and the trust as we go on. Also, really, really important are captive insurance companies. Captive insurance companies are really just an insurance company, excuse me, that you own. And there's no difference between a regular insurance company and a captive insurance company except the ownership. The ownership is owned by the client. And if you think about it, what are the great things about insurance? Well, number one, if you pay insurance, you get a tax deduction. So that's always a great thing. Number two is if you have a claim, well, hopefully they're going to pay your claim. And I say hopefully because unfortunately that doesn't always happen. So the great things about insurance are you get a deduction and hopefully they pay your claim if need be. What are the bad things about an insurance payment? If you pay it and you don't use it, it's just lost money. So the captive insurance company actually is a vehicle and a method where clients can own their own insurance company. So they still get the tax deduction from the business, when they write the check to the captive insurance company in return for the insurance coverage. However, if there's no claims, if there are claims, certainly they're covered by their own captive insurance company, and obviously it's going to pay the claim because, it's your company. But the good thing is, if there's no claims, it all becomes profit to the client. I like it because it helps get money out of the business from an asset protection point of view, but can also really help you, in regards to both income and estate tax. With this being said, you have to be so careful about setting these things up. You have to make sure that you're really using, a reputable tax attorney because the IRS scrutinizes these things. They want to make sure that people aren't doing them just for the tax deduction. And there's so many people out there, who claim to be doing captive insurance companies, and unfortunately, there's so many different nuances that goes into setting up each one of these companies, and it's such a long process, 3, 4, 5, 6 months to set up, that a lot of times they don't tell you about all the nuances until the end when it's too late. So definitely be very careful, who you use, and make sure that you're crossing all the T's and dotting all the I's. There's also both domestic and international captive insurance companies. And, not to say that one is better than the other. We prefer international captive insurance companies. They're a lot cheaper to set up and maintain. They have less capitalization requirements. I believe they have more asset protection. But again, definitely make sure that you're working, with a good tax attorney and make sure that it's set up correctly, because it could be such a great thing for your business, but if not done correctly, it can end up being a nightmare. Talk about Belize a little bit. And again, there's so many different jurisdictions, so I really just picked a few today, and I didn't pick any special ones for any reason. But there's so many different good asset protection jurisdictions. There's Nevis, there's the Cook Islands, there's Belize. People have used Isle of Man. I mean, you can go on and on. And Belize is a really great, the Belize Trust Act prohibits Belize courts, to recognize any claims from creditors of courts in a foreign jurisdiction. So if you go to Belize with a U.S. judgment, it's not going to mean much. They also don't recognize fraudulent conveyance claims based on foreign law. So, if someone from the U.S. is claiming fraudulent transfer, they're not really going to give too much thought to that. Contrast that a little bit with Nevis. Nevis, again, depends on the type of entity, whether it's LLC or a trust, they're going to have to potentially post a bond in order to sue you. And in a lot of these jurisdictions, there's a loser pay rules, which means if you win, they have to pay all of your attorney's fees. Contrast that with the Cook Islands. Cook Islands don't recognize foreign judgments. The burden of proof is beyond a reasonable doubt. I mean, that's 99.9%. And the statute of limitations, it's very confusing. I put on here 1 to 2 years, but it's actually, if you read it correctly, it's anywhere from about 0 to 2 years, the statute of limitation. So, for example, in Florida, if you get in a car accident, there's a 4-year statute of limitation that you have to sue. In the Cook Islands, it's anywhere from about 0 to 2 years. And, what I want to do is just touch briefly kind of on international in general. I didn't really want to today, say, hey, this jurisdiction is better than another. Cook Islands is one of the first places to have asset protection jurisdiction, and I believe they started writing their laws around 1984 and 1989 or so, and it was followed by Nevis and Belize and, things of that nature. So the Cook Islands have definitely been in the industry for a while, and they're a great place to keep your money. And when I say keep your money, I mean set up entities. So just because you set up an entity in the Cook Islands doesn't necessarily mean you have to keep your money there. You might set up a Cook Islands or a Nevis or a Belize LLC or a Cook Islands or a Nevis or a Belize trust, and you might keep your money in a bank in Switzerland or Liechtenstein or somewhere that you feel more comfortable rather than Cook Islands or Nevis or Belize. But what I want to do is really just take a moment and go over international asset protection, as a whole, and what somebody would have to do if they wanted to come after someone who has properly set up, an international asset protection plan. First thing they would have to do is sue you in the United States and beat you. And the reason I say beat you is that in the majority of the cases, absent some punitive damage claims, a creditor, you don't even have to tell them what your assets are, unless they beat you in the lawsuit. So let's say they beat you in the lawsuit, they sit you down for a deposition or a financial affidavit under oath. They then need to know the right questions to ask you. Once they know the right questions to ask you, again, we talked about this isn't about hiding or secrecy. They then have to go to the jurisdiction where the trust or LLC or whatever entity was set up is and where the assets are. And when they get there, more than likely they're going to find out that U.S. judgments are not recognized. So then they're going to have to go hire a lawyer, and it may or may not be a lawyer in that country that can help them. They might be conflicted off the case, so they may or may not have to go to a different country to find a lawyer and then fly them in and relitigate the case. And the majority of the lawyers over there are not going to take the case on a contingency fee. So now this creditor is hourly and potentially paying the U.S. attorney hourly to go back and forth to these different countries to litigate the case. As we talked about, there's a very short statute of limitations when it comes to fraudulent transfer. So, whether or not they can even proceed with the case will depend on, if it's either within or after that statute of limitations. A lot of these countries are going to make you post a bond, which means, you can argue, hey, you have to post $50,000, $100,000, $200,000, because if the creditor loses, they're going to have to pay your attorney's fees because there's a loser pay rules. A lot of these international jurisdictions will require you to have beyond the reasonable doubt proof, which, unlike the U.S. where it's 51%, it's 99.9%. A lot of the jurisdictions don't enforce punitive damages, so while you might be able to, claim, car damage or hospital bills, you might not be able to claim pain and suffering. And also, these documents tend to be 60, 80, 100, 120 pages. Again, they're all different, but most of the time you'll put what's called a CUBA or a flee clause, which really allows the trustee, who's not subject to U.S. jurisdiction, to relocate the trust assets at any time. So even if somebody's suing you in the jurisdiction where your entity is or your money is, at that point the trustee may or may not move it, and they'll have to do the whole thing all over again. I think the last time I checked, the stats were that less than 1% of all international asset protection entities are challenged. So not beaten, but challenged. So again, it's not for everybody. It's for people who have a lot of liquid assets. A lot can be defined in a lot of different ways. I have people who have a couple $100,000 who set up these entities. They want to sleep well at night and make sure they're protected. I have people who have $1 million. They might be in their mid to late 80s. They don't work. They don't drive. They don't own real estate. They don't operate businesses. They just don't have that much liability. But I tell my clients that if they have at least, 300,000, 400,000, 500,000 in liquid assets, at least they should become educated and consider these type of entities. Doesn't mean necessarily they have to create one, but they at least should know what exists and what their options are. And, I just want to touch lastly, on some of the ethics of international asset protection, because, a lot of people say, is asset protection, ethical just in general, regardless of whether it's, domestic or international. And, everybody has their own beliefs, and, my belief is that it's unethical not to do asset protection. You have a husband or you have a wife and you have kids or family, and, I believe that you have a duty, to take care of them. And by not protecting yourself, you put not only you, but your family in a really bad position. And, I don't suggest that anybody go out there, set up these entities and not pay their bills. That's not what we're here for. I tell my clients that, if it's a frivolous lawsuit, I don't want them to pay. If it's a legitimate claim, if they can settle for 5, 10, 15, 20 cents on the dollar, well, we've done our job correctly. And at the end of the day, if you want to write a check to the creditor, no problem. Go ahead, write the check. But put yourself in the driver's seat, because when I speak throughout the country, I always ask people to raise their hand if they've been sued. And I always tell them to keep their hand up if they think they should have been sued. And very rarely, I won't say never, but very rarely do people keep their hands up. So I think in regards to ethics, Nothing wrong with it. Make sure you and your family are protected, but certainly do it in a legal, ethical, proactive way.